In West Virginia, you may have heard that all parents now get 50-50 or equal custody no matter what, but that's not true. It's not automatically 50-50 custody in every case, even though that's where the judge may start. As someone who may have experienced domestic violence in your relationship, there are important things for you to know before you go to court. Going to court can be overwhelming. There are resources that may be able to help. Get in touch with your local domestic violence program. Find your program online at www.wvcadv.org. These programs have advocates who can connect you with resources, help you understand the court process, and provide support. Some domestic violence programs also have counselors. Talking with a counselor can help you deal with your feelings. A counselor may also be able to testify in a custody case later. Domestic violence advocates may also be able to refer you to Legal Aid of West Virginia for legal help. Legal Aid has attorneys who can help domestic violence survivors in some cases. Legal Aid's website at www.legalaidwv.org also has legal information to give you a basic understanding of custody cases. West Virginia's custody law says there are many reasons a judge may not give parents equal or 50-50 custody of children. These are called considerations. There are many of them. We will only talk about a few important ones you may want to bring up in your case. One consideration is whether the other parent has committed domestic violence or has a pending domestic violence case. This could be criminal charges for domestic violence, or it could be a domestic violence protective order. Another consideration is whether a parent has abused or neglected a child, like if a Child Protective Services has found there was abuse or neglect by a parent, or if there is an abuse and neglect case against a parent with the circuit court. The judge may also consider whether a parent is actively addicted to drugs or alcohol, or if a parent has a felony criminal record. If you yourself or the other parent have someone in your life who is regularly around your children with one of these factors in their background, the judge may consider that as a reason parents should not have equal custody. You, as the parent, must be prepared with evidence to show the judge why one of these considerations may apply in your custody case. Evidence helps the judge understand the issues and your concerns. Evidence can be things like your testimony, eyewitness testimony, photographs, screenshots of text messages or social media posts, recordings or videos, medical records, or drug screen results. For example, if domestic violence is a concern, evidence could be photos of injuries, testimony from other people who saw the domestic violence, past protective orders, or past criminal charges. If you have a witness you would like to testify, and you need to make sure they will come to a hearing, you can get a subpoena. A subpoena is a written document signed by someone from the court system. A subpoena can require a person to come to a hearing or require documents to be produced, like medical records. To get a subpoena, go to the circuit clerk where your case is pending. Tell them you want to issue a subpoena. There can be fees or costs for this. You may want to contact the person or agency who will deliver the subpoena to understand if there will be costs. If you need information about a person's criminal records, the county's magistrate clerk should have a public computer where you can look a person up by name. It can be helpful to talk to someone about how to gather evidence. This is another good reason to contact your local domestic violence program to connect with an advocate to point you in the right direction. You need to make the judge aware of your issues and concerns from the beginning of your case. This means that when you file your first documents with the court, you want to list your concerns about the other parent. You can do this in your petition for custody. There is also a specific place for reasons for restrictions on page 2 of the Parenting Plan form on the West Virginia Supreme Court's website. If domestic violence is listed, you should write down information about past protective orders, including the case number and place where it happened. You should also have your evidence, like pictures or screenshots of messages, ready at the first hearing. If you think you will be nervous at your hearing and forget to mention things, you should make a list of the concerns you want to tell the judge. As you discuss these things with the judge, you can cross those off your list. Finally, be prepared for what the other party may say about you. Think about evidence the other party may try to use against you or questions the judge may have for you. If you think the other side has evidence about you that may be harmful, think carefully about how you will respond and explain those things to the judge. If you have dismissed a domestic violence protective order in the past, or asked a prosecutor to dismiss criminal charges for domestic violence against a person, the judge may ask you why you did that. Be prepared to explain and be honest about what happened in the past. The judge will hear both sides at the hearing and then consider all the evidence and factors. Then the judge will decide on what custody arrangement is best for the children. That's why it's important to be prepared before you go to court. Remember, there are places that can help you get ready. You can find information about your local domestic violence program at www.wvcadv.org and legal information, including how to apply for legal aid services, at www.legalaidwv.org.